Good afternoon. My name is John Gotanda, and I am the Associate Dean and Professor of Law at Villanova University School of Law. And I'm here today to talk to you about damages under the CISG. Now, one of the great aspirations of international law is for all countries to adopt a uniform set of rules governing trade so that contract actions can proceed with the greatest amount of efficiency. And to that end, the United Nations has promulgated the Convention on the International Sale of Goods, which has been adopted by over 70 countries. The CISG has proved very successful in many areas, but it has been less successful in one of the areas most important to the parties in a dispute, that is, damages for breach of contract. Indeed, out of all the articles of the CISG, the damage provisions and the payment of interest are likely the most litigated and the most written about. The lack of uniform rules in this area can be particularly problematic because it can lead to similarly situated parties receiving vastly different results. And to the extent that rules are unpredictable and they seem to be unfair, and they may ultimately undermine the usefulness of the CISG because parties may apply a sales law other than the convention. What I'd like to do today is give you a brief overview of the economic provisions of the CISG and then focus on three controversial issues: whether an aggrieved party may recover attorney's fees and costs under the convention; second, whether or not the aggrieved party has to show a requisite level of proof in order to recover damages under the CISG; and how interest is to be calculated under the convention. Let me begin with a brief overview of the economic remedies provisions of the Convention. Under the CISG, if a party fails to perform its contractual obligations, an injured party has various remedies, including damages. The principles concerning the measurement of damages are set forth in Articles 74 through 77, and Article 78 sets forth the general rule concerning the payment of interest for any sums in arrears. The purpose of the damage provisions are to place the aggrieved party in the same economic position that it would have been in had the contract been performed. In other words, it seeks to give the aggrieved party the benefit of the bargain. The basic rules for the recovery of damages are set forth in Article 74. It provides that damages for breach of contract by one party consists of a sum equal to the loss, including lost profits, suffered by the other party as a consequence of the breach. And while the CISG does not provide any specific guidelines for calculating damages, it basically allows for the recovery of three types of damages. First is direct loss, second is incidental loss, and third is consequential loss. Let me turn first to direct loss. The first type of damages here is direct loss, and that's the loss in value as a result of the breach. It's often measured by the difference between the value to the aggrieved party of performance that should have been received and the value to that party of what, if anything, was actually received. In cases where the aggrieved party undertakes measures to place it in the same position that it would have been in had the contract been properly performed, the aggrieved party is entitled to recover the cost of those measures, provided that they were reasonable. Incidental damages are for losses in addition to loss of value from being deprived of performance under the contract. This loss may arise where the breach of contract causes the aggrieved party to incur additional costs in an attempt to avoid further loss. An example here would be storage costs. Consequential damages are for economic losses dealing with third parties. For example, in the case of a breach by a buyer, a seller may suffer consequential damages resulting from the termination of contracts with third parties. Under the CISG, an award of damages must not place the aggrieved party in a better position than it would have enjoyed had the contract been properly performed. Thus, in calculating damages, the amount owed to the aggrieved party is to be offset by any gains resulting from the non-performance of the contract. What this means is that the account must be taken for any gain to the aggrieved party from non-performance, such as expenses that had not been incurred or losses which has been avoided. This is done basically to prevent the aggrieved party from obtaining a windfall. So in short, what Article 74 does is it enables the aggrieved party to recover his damages, direct loss plus incidental loss plus consequential loss, less any gains to the aggrieved party. Article 74 limits damages for breach of contract to those that were foreseeable or not too remote. It thus employs both an objective and subjective foreseeable test by stating that damages may not exceed the loss to which the party in breach foresaw or ought to have foreseen at the time of the conclusion of the contract, in light of facts or matters which he knew or ought to have known as a possible consequence of the breach. The latter, the objective test, asks whether a reasonable party in the same situation could expect the loss from its non-performance. Let me now turn to Articles 75 and 76, which are limited alternatives to Article 74. Article 75 sets forth the method for calculating damages when the aggrieved party has avoided the contract and entered into a substitute transaction. In this situation, the damages are measured by the difference between the contract price and the price in the substitute transaction, together with any further damages needed to make the aggrieved party whole. Now, if the aggrieved party has avoided the contract but not entered into a substitute transaction, then Article 76 permits the abstract calculation of damages under certain conditions. Here, damages are measured by the difference between the price fixed in the contract and the current price at the time of avoidance, together with any further damages. Article 77 of the CISG imposes upon the aggrieved party the mandatory obligation to mitigate its loss. The duty imposed, however, by Article 77 is unique from many other obligations in the sense that there's no affirmative liability for the failure to mitigate. Rather, the failure to take appropriate mitigation actions precludes the recovery of damages that could have been avoided. Now, with respect to the scope of the obligation imposed, Article 77 requires the aggrieved party to take such measures as are reasonable under the circumstances to mitigate loss. If the party undertakes proper mitigation efforts, reasonable expenses incurred are also recoverable. Recovery also may be possible even if the mitigation efforts ultimately prove fruitless. The payment of interest is governed by Article 78. That article simply provides that, in general, the aggrieved party is entitled to interest on any sums in arrears. And this approach is in accord with the generally accepted principle that an aggrieved party is entitled to an award of interest as compensation for the loss of the use of money. So as you can see, the provisions concerning the economic remedies of the CISG provide only a basic framework for the recovery of damages. As John Honold, one of the principal drafters of the CISG, commented, a breach of contract can occur in almost an infinite variety of circumstances, and thus no statute can specify detailed rules for the measurement of compensation that would apply in all possible cases. What the CISG essentially tries to do, according to Honold, is state basic principles that govern compensation when a breach occurs, thereby affording the tribunal broad authority to determine the aggrieved party's loss based on the circumstances of the case. Unfortunately, though, the lack of specificity has resulted in much litigation. There are three issues that have generated significant debate. The first is whether attorneys' fees and costs may be recoverable as damages under the CISG. The second is whether the CISG contains a certainty of loss requirement in order to recover damages. And the third is at what rate interest should accrue on any sum in arrear, including damages. Let me turn first to attorneys' fees. One of the most controversial issues is whether attorneys' fees and costs incurred in a contract action can be recoverable as damages under the CISG. Much of the controversy over whether litigation costs are recoverable stems from a decision by a U.S. appellate court in the Zapata case, where Judge Richard Posner, who is considered to be the father of the law and economics movement, ruled that the answer to that question was no. Basically, the court reasoned that litigation costs are procedural matters that are outside the scope of the CISG's substantive provisions. And as a matter of procedural law, the recovery of litigation expenses is to be determined by reference to domestic law applicable for resolving the dispute, which in this case was the American rule. Now, by contrast, courts and tribunals in other jurisdictions, such as Germany and China, have allowed for the recovery of litigation expenses under Article 74 of the CISG. The rationale for this view is that the convention must be interpreted autonomously and characterizations of domestic law are irrelevant, and that recourse to domestic law should only be had as a last resort. Thus, it has been argued that Article 74 must be interpreted broadly in accordance with the principle of full compensation, which necessarily calls for the inclusion of an agreed, or that the agreed party should be able to recover attorney's fees and costs associated with vindicating its rights. Otherwise, the agreed party would remain less than whole. Thus, two views have basically emerged here. The first view is that the recovery of litigation costs are governed by domestic procedural law and not the CISG. And the second view is that litigation costs are recoverable under the CISG. The second problematic area deals with whether the aggrieved party needs to show a requisite degree of certainty in order to recover damages under Article 74. The text of the CISG does not address this issue. As a result, there has been much debate over whether it's a procedural matter to be resolved according to domestic law, or whether it is a substantive matter that's addressed by the CISG. The problem is that the certainty requirement has often been associated with domestic rules of level of proof, which can vary widely. As a consequence, some courts have denied claims for damages on the grounds that they were not proved with mathematical precision, while others have allowed recovery if they were proved with reasonable or sufficient certainty. The issue of the rate at which interest accrues is perhaps the most litigated under the CISG. And although Article 78 provides an obligation to pay interest for any sums in arrears, without regard to fault, it does not specify the particular rate or the method for determining such a rate of interest. As a result, courts and legal scholars have offered various methods for determining the rate at which interest should accrue. Most courts and tribunals apply a domestic statute or rule to determine the appropriate rate of interest. Others, though, have applied a commercial rate based on the CISG. The problem here is that statutory rates can vary widely among jurisdictions, and in many instances they do not change to reflect economic realities. Thus, the difference in terms of money between applying a statutory rate or market rate can be significant. Now, with each of these issues, attorney's fees, certainty, and interest, the determination most frequently turns on whether the court views the issue as one governed by substantive law, the CISG, or procedural law, to be applied, filled by domestic rules. The lack of agreement among decision makers has resulted in damage awards that seem inconsistent or arbitrary. And what this does is it undermines predictability and ultimately the primary purpose and legitimacy of the CISG. I believe that courts and tribunals should resolve these issues without resort to the substance-procedure distinction. Instead, they should try to find a solution within the CISG itself through an analogical application of specific provisions on the basis of principles underlying the CISG as a whole. Now, why discard the substance-procedure distinction? Whether a matter is considered substantive or procedural varies from jurisdiction to jurisdiction and may depend on the circumstances of a particular case. Consequently, relying on the substance-procedure distinction in cases where jurisdictions differ over the classification of a matter can be counterproductive and lead to conflicting results. The distinction is also highly artificial. As one court noted, except in extremes, the terms substance and procedure prescribe precisely very little except dichotomy, and what they mean in a particular context is largely determined for the purposes for which the dichotomy is drawn. The substance procedure analysis is also problematic because it's an easy way for courts or tribunals to apply laws that they are most familiar with to resolve difficult issues, thereby avoiding the CISG's interpretative analysis and ultimately undermining the purpose of the CISG to promote uniformity in its application. So the approach that I believe is best appropriate to resolve issues concerning attorneys' fees, certainty, and interest calls for the tribunal to first decide whether the issue can be decided according to the literal text or plain and natural reading of the applicable article. Now, if the result is not formally imposed by the relevant article, then it must be determined if the issue was one that was deliberately left to national law. If the issue was not deliberately left to national law, according to Article 7.2, a court or tribunal must attempt to resolve the issue in conformity with the general principles on which the convention is based. This means that a court or tribunal should try to resolve the unsettled question by means of liberally applying specific provisions of the CISG by analogy. Only in the event that this issue cannot be resolved using this analysis should the court or tribunal turn to domestic law to settle the matter. Applying this interpretative approach would result, in my view, of the unsettled issues being resolved through the application of general principles on which the CISG is based, as opposed to domestic law or rules. First, applying the interpretative approach to the issue of whether attorneys' fees and costs may be recoverable as damages would, I believe, result in the aggrieved party not being able to recover legal expenses associated with litigation as damages, although I believe it's a very close case here. The starting point is the interpretative approach is Article 74. Article 74 does not explicitly provide for the recovery of litigation expenses as damages, nor does it prohibit, though, its recovery. Moreover, the history that led to the drafting of Article 74 is silent on the issue. Thus, the matter is not one that explicitly falls outside the scope of the CISG. Article 74's principle of full compensation seems to support the view that litigation costs and expenses should be recoverable as damages. This is because the failure to do so would leave the aggrieved party less than whole. However, there are other provisions of the CISG that do not support the recovery of litigation expenses as damages. In particular, interpreting Article 74 as providing for the recovery of attorneys' fees and costs would be contrary to the principle of equality between buyers and sellers as expressed in Articles 45 and 61. If litigation expenses were awarded as damages under Article 74, an anomaly would result where only the successful claimant would be able to recover litigation expenses. The ability to recover damages under Article 74 is grounded upon a breach of contract. Thus, a successful respondent will not be able to recover its legal expenses if the claimant has not committed a breach. Therefore, the purpose of awarding attorneys' fees and costs to make the prevailing party whole for costs incurred in the litigation will not be realized in those cases in which the respondent prevails. Accordingly, the overall design of the CISG appears to indicate that litigation expenses should not be recoverable as damages under Article 74. Now, there's another point to be made with respect to attorneys' fees and costs. These costs and fees are not really losses for breach of contract. Rather, they are litigation expenses that arise in resolving disputes in a wide variety of actions, including tort and property actions. And, when awarded, they may be given for reasons apart from a breach of an obligation of contract. It is thus difficult to see that these costs and fees are truly damages for breach of contract. I should add that I've studied numerous laws on attorney's fees and have generally found that one-way fee-shifting statutes are typically enacted to encourage certain suits because of the plaintiff's lack of resources to bring suit or because the legislative body wants private parties to engage in a policing function. I do not believe that these policies here ultimately support a one-way fee-shifting regime under the CISG. Let me now turn to the certainty issue. Applying the interpretative approach to resolve issues of whether the CISG imposes a certainty of loss requirement would impose upon the aggrieved party the need to show with reasonable certainty that it suffered damages as a result of a breach of contract. Like attorney's fees, the certainty of loss requirement is not addressed by Article 74, and it is not an issue that's specifically excluded by the CISG. However, the principles set forth in various other articles provide guidance on how to interpret Article 74 on this issue. The language of Article 74 does state that the breach of contract consists, or damages for a breach of contract, consists of a sum equal to the loss suffered, including lost profits, as a consequence of the breach. Thus, Article 74 recognizes that an aggrieved party has to have sustained damage as a result of a breach of contract, or that damage is likely to occur. Another part of Article 74 aids in how to resolve this issue. Specifically, Article 74 addresses the related issue of foreseeability, or remoteness of loss, thus recognizing explicitly that there are limits on the principle of full compensation and that the breaching party is not liable for certain losses. In addition, because the CISG expressly addresses the issue of foreseeability, no one doubts that the certainty requirement, or that the requirement of causation of damages is implicitly required under the Convention. Thus, the principle that damages must be in existence in order to be recoverable can be derived from the Convention. Now, once it's established that a certainty of loss is required, then the requisite standard can be deduced by analyzing various articles of the CISG. This analysis leads to the conclusion that an aggrieved party must show with a reasonable degree of certainty that it has suffered damage as a consequence of the breach. A reasonableness standard with regard to certainty of loss can be inferred from other provisions and would be consistent with the CISG as a whole. Indeed, as Professor Bonnell writes, there are over 24 provisions in the CISG that provide for reasonableness, and he writes that these references demonstrate that under the Convention, the reasonableness test constitutes a general criterion for evaluating a party's behavior to which one may resort to in absence of any specific regulation. It should be noted that a more exacting standard here would be also contrary to the purpose of Article 74, which is to provide for full compensation to the injured party. Requiring an aggrieved party to prove damages with mathematical precision would, in many instances, prevent that party from being fully compensated for its loss. In particular, it could preclude claims for lost profit, which are the only damage specifically mentioned as being recoverable under the CISG. In fact, Article 74 specifically included a reference to lost profit to ensure that it would be recoverable and that an exacting certainty of loss requirement could thus be viewed as contrary to Article 74. The final issue here is the calculation of interest. In the case of the calculation of interest, and in particular the interest rate, the interpretative approach would call for interest, I believe, to accrue at a rate corresponding to that of a commonly used savings vehicle in the country in which payment is to be made. Now, Article 78 is silent on this issue of how interest should be calculated. The reason it was not more specific is because the drafters couldn't agree on a more detailed provision. Now, under such circumstance, it may appear that the CISG deliberately rejects an extension of Article 78. However, a closer examination indicates that that's not the case. As John Honold writes, Article 78 was, quote, designed to establish a general rule that would be free from the vagaries of domestic law. Thus, leaving the calculation of interest to domestic law would produce the type of non-uniformity that the drafters sought to avoid in promulgating interest under Article 78. Thus, perhaps the evidence is inconclusive on its exclusion. So with respect to determining the rate itself, An analogous provision here to look to could be Article 74, which provides that damages are equal to the loss suffered. Article 74 thus embodies the principle of full compensation. The purpose of Article 74 is similar to the goal of interest. Thus, the interest rate should be a real commercial loss and not a contrived loss under a domestic statute, which often do not reflect sort of changes in economic realities. Also, using a statutory rate of interest could, in some instances, be contrary to the CISG. For example, if the prevailing market interest rate is higher than the interest rate set by statute, the debtor could essentially earn money by delaying payment, earning a higher rate of return on the invested funds. Now, on the other hand, if the prevailing savings rate is much lower than the fixed statutory rate, the result could be that the aggrieved party is overcompensated. So as best to achieve the goal of the CISG, courts should adopt a uniform approach for awarding interest at a rate which compensates an aggrieved party for the loss of the use of money. Now, I believe that interest should accrue at a savings rate that's most commonly used in the country of the currency in which payment is to be made. It's not appropriate to use a lending rate because Article 74 awards the aggrieved party actual damages, including any loss from borrowing money to continue operations because of the debtor's default. Thus, an aggrieved party who's forced to borrow money can be returned to its pre-injury condition pursuant to Article 74. Article 78 provides for interest in the alternative cases where the aggrieved party was not forced to borrow money to continue operating after the debtor's breach. In contract disputes where the aggrieved party is not forced to borrow, the aggrieved party would conceivably be holding the money, using some sort of savings instrument, or reinvesting the money in the company. By awarding interest at a market savings rate, the aggrieved party would be in the same position it would have been in had it invested the money. That is, this approach restores the aggrieved party to its pre-injury condition by compensating it for its lost opportunity, so by not being able to earn a return on the sum in default. In addition, it prevents the defaulting debtor from being unjustly enriched, and it also provides a uniform, easily applied rule to create certainty in international contracts. So in sum, the CISG has been intended to provide a uniform set of rules for the international sale of goods, and has been very successful in many areas, but this goal may not be met with respect to one of the most important areas of the CISG, damages for breach of contract. The lack of uniformity with respect to awards of damages can, in my view, be traced in a number of instances to the improper use of domestic procedural law to fill gaps in the CISG's provisions. The practice of determining whether an issue is governed by applicable procedural law instead of the CISG is outdated, it's counterproductive, and it should be abandoned. Instead, tribunals should try to fill gaps by trying to find a solution within the CISG itself through an analogical application of specific provisions on the basis of principles underlying the CISG as a whole before turning to domestic law. This approach would lead to a more consistent and predictable awards of damages and would ultimately further the goal of the CISG to create a uniform commercial law. Thank you.